With some really interesting statistics that I came across in preparing for tonight's discussion. So the statistics show that white males are overrepresented on state appellate benches by a margin of nearly 2 to 1. Almost every other demographic group is underrepresented when compared to their percentages in the population. And there is also evidence that the number of black male judges is actually declining. So that's the one group that is actually on the decline. There are fewer female judges than male judges, even though our nation's law schools graduate more women than men and enroll more women than men every year. And a recent study by the Brennan Center actually found that states with appointed processes, like the state of Maryland, actually do worse in terms of diversity on the bench than states with elected judges. So tonight we're going to talk about what we can do about those figures and whether, in fact, those figures are cause for concern at all. Do we care about diversity on the bench? And we're going to hear from tonight's panelists with regard to that.
The idea of a non-diverse bench absolutely should send shivers down all our spine. It is important that every voice be heard in the community. It is important that judiciaries look like America, and it is important that the perspectives that enrich our lives come to bear on the formulation of law and the delivery of justice. And I could have brought a list of very distinguished American lawyers and judges who have made this point in so many beautiful ways. One that sticks with me is this great quote that I've used many times from Cardozo, who makes the point that we are all, he doesn't use the word bias, but he makes the point that we all have a perspective. We all are the product of our life experiences. And the suggestion that some have made that judges are kind of fungible and kind of like Watson the computer who always gives the right answer, it's just not true. It's not true. Law is the product of an accumulation of experiences and perspectives. It's very important that, like the ABA and other legal organizations have worked for many years to achieve, that we have a diverse bench drawing from every corner of the community and the profession to ensure that we have true justice.
And can we reconcile that notion that we need a diverse bench with the notion that justice is blind, that justice is when they don the robes, walk, everything else?
I think so. A diverse bench, at least where I sit in Montgomery County, where a significant portion of the population is Asian American, and a large portion of the population is an immigrant population. And not just an immigrant population, but a recently arrived immigrant population. Well, I happen to be an immigrant myself. I came to this country in 1968 and grew up speaking another language. I grew up in what is considered the ghettos of Los Angeles. If you're familiar with Los Angeles, it's the Rampart division of Los Angeles, and that's my hometown. So, and the reason why I bring this up is, as I was saying that to the audience, I saw recognition in nodding and agreeing with what I was talking about. And just by virtue of my being up there, speaking to an audience like that. Now, if I bring that to a courtroom where we have recent immigrants who, for whatever reason that they're I may, being from a similar background, being of an immigrant background, of an Asian American background, I can certainly empathize. Does that mean that I change my ruling? Of course not. But it does color how I as a judge view certain issues, and it may also color how I assess how others view those issues behind the bench.
Whether it be a family law case that deals with some type of discipline, or whether it be a criminal case where you've got somebody in front of you who really doesn't know why what they did is wrong or against the law, and you have to be able to not lose your mind because the person doesn't get it, but you understanding sort of how the law evolved, how this person's culture may have evolved, or what world that person lives in versus what the world we wish you lived in. Those are the types of things. So I think the diversity is not just race and gender, but also just life experience.
With Justice Marshall in the room, the conversation is different. The conversation is different. The outcome of the case may not be different. And in many instances, it won't be. And in many instances, it shouldn't be, right? But there is a richness that is brought from the diversity of experiences. And what we had in Justice Marshall, a Baltimore boy, you know, he brought something to those discussions that a Catholic from Newark, which is Justice Brennan, a cowgirl from rural Arizona, Justice O'Connor, they can't bring what Justice Marshall can bring. And all of those voices need to be in the room. And I can tell you, you know, after, what, 22 years as a trial judge, a lone ranger, as it were, having now had the great privilege to serve on an appellate court for a year and a half, I can tell you it makes a difference. I can assure you it makes a difference in the room when there are 3 judges. And, for example, there's a woman, and it's a sexual harassment case. And Justice Ginsburg has made this similar comments. So one's life experiences informs one's performance, won't often change the outcome of a case, but sometimes what's important is not so much changing the outcome of the case, but changing the court's voice and how the case is articulated.
I think we sometimes forget that at the circuit court level, or even at the U.S. District Court level, the law changed over the years based on the way it impacted people. And so we have to be able to empathize or understand how a particular law is impacting people in order to be a catalyst to change it if it ever needs to be changed. So, for example, you know, separate but equal was the law. And it was okay with everyone until some judge was able to realize this is impacting this little girl in a way that the appellate court, the Supreme Court, could not have imagined. That can't be what they meant. So to the extent that circuit courts, and someone asked me this before, well, you know, you're bound by the appellate court. Yes, until someone can show me that it's having an impact on someone in the public that I can understand or understand, you know, what's happening, so that I can say, well, that is what the law is, but it could not possibly apply to this set of facts. And then that's the catalyst for change. And so I think at every level, it's important, and for different reasons at different times.
Well, the highlights of how I got to where I am now is public service is really the highlight. Most of my career has been in public service, and then part of it has been in private service, as you might have noticed in my bio. But it's really, I base a lot of what I know and how I do things based on my career in public service as Assistant Attorney General and as an Associate County Attorney. My litigation experience has been at the state and federal trial and appellate courts levels. And most recently, before becoming a judge, I had been trying cases in Montgomery County in the circuit courts and in the Greenbelt District Court doing jury trials. And, you know, one day someone suggested, have you considered applying for a vacancy? Which was kind of the barometer for me to decide, well, maybe I should. Because first as an Asian American in Montgomery County in Maryland, there never had been an Asian American on the bench. I never thought it possible, but when someone suggested it, someone whose opinion I respected, I did think to do it. And after 3 tries, I did do it. And it went according to someone's plan.
I think the key for me, and being able, I think, to reach this goal at such a young age, I don't know what's my butt, right? So, the key, for me, is the diversity of the practice that I had in the years that I did practice. I started out as an assistant public defender, so I did the criminal defense law. I left within the public defender's office. I did juvenile delinquency. I had worked on some juvenile delinquency issues that were global before actually representing the children in court, and then having represented the children. I worked in the district court as an assistant public defender. I worked in the circuit court as an assistant public defender. I had, Baltimore City, you get 11 jury trials in 11 months, and then, you may even get more than that, but you actually, you're going to trial all the time, and so the trial experience that you might get in a different practice may take longer if you were not in public service. But again, I'm not saying that that's the key. By the time I applied for this position, I had comfortable experience, not just a case or two, but comfortable experience that I knew sort of how to handle a strong or a large civil litigation or a large criminal case or a large employment case or whatever the situation would be.
Well, like my colleagues, my path was also largely through public service. But I have to say, I spent very little time between coming to believe I wanted to be a judge and actually becoming a judge. It was not really ever an aspiration. I clerked for two very fine federal judges at the trial and appellate level, and I think I was largely convinced by my close-up look that I didn't want to be a judge. It was hard, tortured decision-making. But more importantly, I just saw myself as sort of a hotshot litigator, and specifically a civil rights litigator. That's why I went to law school. That's what I wanted to do. And indeed, immediately after my clerkships, I went to the Justice Department Civil Rights Division, where, frankly, if the 1980 election had turned out differently, I probably would have spent a career, I would like to think a distinguished career, as a civil rights litigator. I love to tell this story. I taught civil procedure. And the thing about federal civil procedure is to do it well, and I like to hope I did it well, but to do it well, you really become an expert in every field of law. And the reason for that is when you assign a civil procedure case, the case is about something other than civil procedure. It's a torts case, or it's a contracts case, or it's a statutory interpretation case. There's always some background law, substantive law, and Maryland being Maryland and law students being law students, always challenging the professor, I full well understood, Professor Hutchins, right, that you absolutely had to be an expert on everything. And so what teaching civil procedure gave me was the opportunity actually to read a lot of law. And reading that law, some of it very ancient, some of it more current, I came to realize, and this will sound pokey, but I've said it before, and it's my story, I'm sticking to it. I came to realize that judges are teachers. Judges really are teachers. To the community, to the lawyers, to the litigants. When you make a decision as a judge, you're sort of teaching people about what the law is, what democracy is, what the rule of law is about, etc. And so it was in that really moment in time that something clicked in me and said, well, I love teaching so much, maybe I would make a good judge. And I was in the right place at the right time and got appointed to my first position as a member of the District Court of Maryland, the Court of Limited Jurisdiction here in Baltimore, which I loved. I spent a year in landlord-tenant court, did misdemeanor criminal stuff, non-jury stuff, really loved it, and then over time sought and was appointed and then ultimately re-elected to this court, shortly after which I was appointed to the federal trial bench by President Clinton. So it's been 24 years of just wonderful experiences, constantly learning and teaching.
One of the things, in describing all of your past events, one of the things that at least stood out to me, and may or may not have stood out for the audience, was that all of you logged some time in an agent's office or a U.S. Attorney's office. Is that required? So there's certainly this perception that you cannot ascend to the bench with just a career path at the public defender's office. And your career path would seem to suggest that that's true. Do you think it is true, or?
Can I take a stab at that
Absolutely.
first? Only because, even as a young lawyer back in 1985, I saw that the Attorney General's office was a clear path. And you know, if you look at the state's attorney's staff, the same thing, you're going to see that, and the public defender's office, the same thing. But that was an impression that was left on me, and it was really an indelible impression. And as a young lawyer, it didn't seem to me that that's the path that I was going to take, but it ended up being the path that I took. And looking back on it now, I feel very fortunate that I had the opportunity to do that. And in fact, the Deputy Attorney General who hired me in the AG's office under Steve Sachs, in fact, became a judge himself. And, you know, for my part, I can kind of trace back connections from lawyer to judge to lawyer to judge, so on and so on, going back for many years for people, you know, that I know directly who have taken that path.
You guys agree, or?
I don't know that I agree, and I don't know if I'm the right person to ask, but I don't know that it's necessarily required. I would be hesitant to say that. I mean, I think I agree with Judge Kim that the stats are there. However, I think, from my experience, I think what nominating commissions want to see is they want to see your quality of work, which at the Maryland Attorney General's office, there's sort of no escaping the high quality of work. My experience has been nominating commissions, they want to know, one, your quality of work. They also want to know your familiarity with the courtroom. So to the extent that public service gives you a lot of that in a little bit of time, sure, public service is helpful, but I'd be hesitant to say that that's the answer.
I think Judge Osby's analysis is really right on the mark. It's certainly not a requirement as such, but there is a dynamic that involves politics, because becoming a judge is a political process. There's no question about it. Obviously, once one becomes a judge, one certainly hopes that politics is entirely out of it for each of us and all of the judges. But the process of getting there is a political process, and so people in government agencies, I mean, you mentioned somebody like Steve Sachs, and he's a giant of the Maryland bar. George Nielsen, the city solicitor for Baltimore, is a giant of the Maryland bar. And so these people, through the political process, head these offices and attract really high quality people who in turn attract younger lawyers. And so it's a dynamic that feeds on itself. The same thing is true, by the way, or significantly so, in the federal system. If you look at the federal bench in Baltimore City, and you say, well, who was an assistant U.S. attorney? Or to say nothing of the U.S. attorney. And so you see that historically, there are certain paths that you can take that don't assure you of anything, but certainly distinguish you from others who haven't been in those positions.
One thing that I thought was striking is, Judge Kim and Judge Osby, you both said you needed a little nudge to sort of make the application happen and get it in. Judge Davis, I don't know if that was something you needed to, or if you jumped in there on your own, but I was wondering why.
One, you don't look like any other judge on the bench. I was the very first Asian American applicant in the state of Maryland, in the history of the state of Maryland. I was the second appointed by a month, Judge Shin Hong here in Baltimore City being the first in July of 2002 and then me in August. But until I applied, no one else had applied. In 1994, I think it was. And so I didn't until then, and even then, I didn't think that I was being taken seriously. I did need that nudge because the bar didn't reflect me, and I didn't reflect the bar. I'm proud to say today that Montgomery County is a far different place, and the executive committee does reflect a diverse bar and encourages that diversity. But back then, it did not. Well, not that it didn't encourage it, but it didn't reflect.
I was applying for the District Court of Maryland, and there were those who thought that I wouldn't enjoy it, if that's the right word, that I would reasonably quickly, not like the crush of people, a 9:30 traffic justice, and I just thrived in that environment. My first promotion, we call it that, from the district court to the circuit court, I had to be pushed. And I didn't really want to go on the circuit court. You know, I didn't want to do robberies and rapes and murders. I wanted to do landlord-tenant, you know. So I took the application, and I literally, the day it was, before it was due in Annapolis, I dropped it in a mailbox here in Baltimore City, thinking, oh, it'll never get there. It got there. And when the offer came, I had to accept it.
The other thing we're going to discuss later is don't wait till the last minute.
Unless you don't want them. Unless you don't want them.
Okay, so instead of telling them what they should do, like, we'll tell them that later, that'll be the second. What should people be doing? So if people know they've got that hankering to go onto the bench and they're thinking about it, are there things that applicants, or even prospective applicants, can be doing now to prepare themselves for the process when ultimately they decide to jump off the cliff?
Well, I can say, at least for Judge Kim and I, the application itself was pretty much the same. So if you're looking for an appointment at the state, the first thing I would say do is get a hold of the application and familiarize yourself with the application because it does take some time to fill out. You do have to tell them all the things that you've done, and you don't want to forget a lot of the things you do because they ask you about your experience within the last 5 years, about some things, or within the last 2 years for something. And if you're taking CLEs here or you have cases, you want to be mindful of that and keep track of all of those things. And also you want to familiarize yourself with the people who are involved in the process. So every single bar association has a judicial nominating committee. So you want to familiarize yourself with all of the specialty bar associations, the minority bar associations, your local bar association, and their process and what they're looking for. So that, to start, I would say start there.
Does that mean you have to actually go out and join all those bars, or just kind of...
Let me say this, even if you're not appointed by judge, I don't know why you wouldn't join all. I mean, you're an attorney practicing in the state. You're practicing with all of the same people. It means a world of difference to make sure that you're involved. I used to be the president of my own city bar association, and before that, or before after that, I was doing the judicial nominating committee things, and I was always on it, and we always interviewed, and we interviewed all over the state. No matter where you're applying, don't be fooled into thinking Monument only wants to see the judges in the city, because we practice everywhere. So anyway, so we'd interviewed for every seat everywhere. But in my process as being an active member in this bar association, I had the opportunity to meet Judge Wade in Dorchester County shortly before he was appointed. Well, I ended up a case in the circuit court for Dorchester County, and if you've never been there, it's very, okay, let me tell you.
Southern.
Until then, I have been in every court in the state working for the Attorney General's office, which was, having all over the place. I get there, and of course I get there early, and I'm sitting in the hallway, and I kid you not, an attorney walked up to me, because I clearly was not a client of someone, and he walked up to me, and he had on his matlock suit. And just blatantly says, I don't believe I met you. Like, who are you? That's what he said. I don't know. All right, so I introduced myself, and then it became a whole other sort of small town issue. Attorney General, what's the Attorney General going to our town? I'm like, oh gosh. I just have a case, So we're all in the hallway, the court's not open yet. We get into the courtroom, and we're all sort of sitting there, and we're waiting for the judge to come out. I didn't know who the judge was going to be. So sitting there with the other matlock, and he's like, she's our Attorney General. And you could hear them. It was, and I had been practicing law for a while, but things can still make you uncomfortable after a while. I'm like, okay, great. And there's no other African American. I don't even think there were any other women lawyers in the room. There were probably like 3 or 4 lawyers total. So the judge comes out, and he calls one case, and he calls the next case, and he says, we introduce ourselves, and he says, Ms. Osby, it's good to see you again. And the hush across the room, my comfort level was here, my confidence was here, And the whole case took like 5 minutes, but that was something that came out of me being an active member in a local bar association, and it just, you know, it meant the world. But so I say that to say I don't see any reason why you shouldn't be active members in the local and specialty bar associations anyway. But if you're going to be a judge, you certainly should